So, hi, Assalamualaikum warahmatullahi ta'ala wabarakatuh. My name is Muhammad Khonazim bin Muhammad Nazaruddin and I'm from Group 4 Bunga.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Aiman bin Bahari from Group 4 Bunga.
Assalamualaikum, my name is Muhammad Arief bin Suhaimi. I am from Group 4 Bunga.
Hi, Assalamualaikum. My name is Siti Nur Faizah binti Fidaus.
So, firstly, I'm going to present about the discharge of contract. So, what is the meaning of discharge of contract? It is the contract has come to an end. Second, the parties to an agreement are free from their contractual obligation. And third one is neither party has any further obligation under it, and a contract may be discharged by one of these four following ways, which first one is discharge of performance, second discharge of agreement, third discharge of frustration, and lastly, which is the fourth one, is discharge by breach of contract. So for the second one is discharge by performance, which firstly is usual method for the discharge of contract, and second one is parties to the contract perform the duties completely, and the third one is performance must be exact and precise and in accordance with the terms and of the contract. So for the fourth one is section 38(1) of Contract Act in 1950, the parties to a contract must either perform or offer to perform their respective promises unless the performance is dispensed with or excused under this act or of any other law. And lastly is when the parties had carried out exactly when they have undertaken to do, there is a complete discharge, but if only one party perform his part of the bargain, he alone will be discharged. Okay, so for the third one is discharge by agreement or consent, which the first one is either by express or implement consent. Second one, the consent of all parties to the contract is necessary. And lastly, which is the example, is waiver, release, novation, remission or rescission.
I am going to talk about the other 2 points from discharge of contract, which are discharge by frustration and discharge by breach of contract. So the meaning of discharge by frustration is a contract can be frustrated when there is a change in the circumstances which renders the contract legally or physically impossible of performance. In section 57, 1 of Contract Act 1950 have mentioned that an agreement to do an act impossible in itself is void. So there are 4 circumstances of impossibility of performance, which are the first one is distraction of a subject. Versus Henry, which a room was hired for the sole purpose of watching the coronation process of king, but it was cancelled because of the king's illness. Third one is about supervening illegality. It happened when the contract became illegal. The example case is about Bernie versus Trauma Mines Limited company. It about Japan invaded Malaya. Therefore, the contract of employment was discharged because it became illegal. Last part is death or personal incapacity. It happened when the contract is discharged on the death or incapacity or illness of a person if the performance of a contract is depends on his personal skill and ability. The case is about Condor versus the Baron Knight Limited Company. It is about drama employee was ill and not fit to perform, so the contract was discharged. So that's all from the discharge of frustration. So the last one is about discharge by breach. It happened when one of the parties failed to perform his obligation. It indicates to other party an intention not to go on with the contract. The party is said to repudiate the contract. The disability to perform is due to the fault of the party concerned. They have 3 forms of breach, which are refused to perform, disables himself from performing promise, and repudiated liability under contract. So the effect of breach is an innocent party may put an end to the contract and must restore any benefit which he may receive from the other party. In section 65 of Contract Act 1950. So that's all from discharge of contract.
I will explain about the damages. What is damages? Damages is the court estimated compensation in money for the treatment of injury sustained by the plaintiff in contract of tort. One of the case is Hartley versus Bezendel. The court decide that damages may only be ordered in respect of loss which either 1. Arises naturally, according to usual cause of thing for the breach, and second is which the parties may be reasonably supposed to have contemplate in making the contract as the probable result of the breach of it. Next is section 74 of Contract Act 1950. An injured party is entitled to natural damages and special damages. Natural damages. Damages arising naturally and directly out of the breach in the usual course of the things, while the special damages are those which are indirect result of an injury which do not necessarily result from such an injury. They are out of pocket costs directly resulting from a breach of contract, negligence or other wrongful act by the defendant. Special damages can include medical bills, repairs and replacement of property, loss of wages and other damages. Next is M of rewarding damages. M of rewarding damages is to give relief to the innocent party for the losses incurred, not to punish the party who is in breach. One of the case is Tam Chioto versus Associated Metals Smelters Limited. Held, a failure to send a smelter that could burn up to 2,000 is a breach of contract. Defendant can expect the losses that might incur from that breach. Such compensation is not to be given for any remote and indirect loss of damages sustained as a result of the breach. Damages of unspecific amount divided into 3 types. The first is substantial. Substantial is a reward given is to put plaintiff in a place that he should if defendant perform the contractual obligation. Second is nominal. Nominal is a small reward to plaintiff after he showed that there is a breach of contract, even though there is no real losses incurred. And lastly is exemplary. Exemplary is a reward given is far higher than the losses incurred. Next, I will explain about the quantum merit. Quantum merit is a claim that can be made by the plaintiff who has performed obligation under a contract and then choose to rescind the contract after defendant's breach. Court will order a value which is adequate.
So next is section 11, 1 of Specific Relief Act 1950. Specific performance may be granted by the court in the following circumstances. The first one is the contractual obligation is a trust. Second one is actual damage cannot be ascertained. And the last one is a breach cannot be adequately relieved by compensation of money. So next is about injunction. Injunction is a decree by the court ordering a person not to do a certain act is an equitable remedy given at the discretion of the court. First one is Specific Relief Act 1950. Injunction is a remedy classed in Part 3 as the presumptive relief. The next one is presumptive relief. Means the relief where a party to the contract is prevented from doing particular act which he is under an obligation not to do. So the last one is Section 50 of Specific Relief Act 1950. Preventive relief is granted at the discretion of the court by injunctions, temporary or perpetual. So more about injunction is temporary injunction. Temporary injunction are such as are to continue until a specific time or until the further order of the court. They may be granted at any period of a suit and are regulated by the law relating of civil procedure. Next is illustration. If someone's intellectual property is being infringed upon, the court may decide to issue a temporary injunction to ensure that the alleged infringement does not continue while the trial takes place.